Thank you for joining us. My name is Helene Weiss. I'm with the Marsh law firm, and I'm joined today by Kat Thomas. Kat, thank you so much for being here. Kat is with the Thomas Legal Counselors, and today we're going to be discussing the Gender Motivated Violence Act. So thank you again so much, Kat, for talking to me today about this.
No, thank you so much for having me. This is a really important law, so I'm glad we're finally discussing it.
Yeah, me too. This is hopefully a lot of people can get something out of this. We want to give an introduction to what the Gender Motivated Violence Act is, who can sue under it, who can get some justice under this act, when does it get passed, where is it getting passed, and hopefully this can be enlightening for people who are listening and tuning in. So let's get started. The Gender Motivated Violence Act is being referred to as the GMVA, and we've heard it be referred to as the Victims of Gender Motivated Violence Protection Act as well. Right now, the GMVA, or the Gender Motivated Violence Act, is not a law, but it's becoming a law on March 1st, 2023. So first, a couple things about the GMVA. It's not the Child Victims Act, and it's not the Adult Survivors Act. We've heard a lot about these two different laws that also seek justice for survivors of abuse. But the Gender Motivated Violence Act is also seeking justice for victims of abuse, and it's doing it through a completely different avenue. So we wanted to take some time today to explain what is going to happen once this act really becomes a law in 2023. So the GMVA is a new amendment to the New York City Administrative Code, and it gives victims of gender motivated crimes this new opportunity for justice. And the way it does that is it includes an extended statute of limitations and a 1-year look back window that didn't formerly exist. So one of the cool things that about the GMVA is that the people who are allowed to seek justice, the potential plaintiffs in these lawsuits, could be, it's not age barred from what we're seeing right now. Is that right, Kat?
Yeah, there's not, unlike the Child Victim Act, this doesn't have any age requirement added to the language of the statute at all. That's not the basis for the statute. It's not exclusive to child or exclusive to adult.
Right. So that's different than what we've seen in the Child Victims Act and the proposed Adult Survivors Act right now. It appears the way that the GMVA is written that there is no age requirement or age limit for people who want to seek justice and potentially file a claim or file a lawsuit under the Gender Motivated Violence Act. Now, who this act protects, let me read specifically straight from the New York City Administrative Code on this. A crime of violence motivated by gender, and a crime of violence committed because of gender or on the basis of gender, and due at least in part to an animus based on the victim's gender. So really, a gender motivated crime of violence can be any form of assault that is motivated by sexist beliefs. Sexual assault can be a form of gender motivated violence. But because of the terminology that's used in the law, many victims of sexual assault now will have the ability to sue their abuser in a similar fashion to the passing of the Child Victims Act with some different provisions. Another thing in the GMVA, a crime of violence, and again, I want to read straight from the code here of how they really define what a crime of violence constitutes. So that's an act or a series of acts that would constitute a misdemeanor or a felony in the state of New York, a misdemeanor or a felony against a person or against property as defined in state or federal law. And that's a really important distinction. So it's a crime against a person or a felony or misdemeanor against property if the conduct presents a serious risk of physical injury to another person. And a big caveat here is that these acts do not need to have been prosecuted by a district attorney's office, and the person that the defendant, the target defendant in these suits, does not need to have been convicted of a crime for a plaintiff to effectively, sue someone under this act. Another big thing that is, was a recent, my understanding was that it was a later on addition, but that now it is part of this act, is that not only will victims be able to sue individual abusers, but that they'll also be able to go after institutions that perpetrated abuse. Is that your understanding too, Kat?
Yeah, that was a really big deal when we saw that amendment. And, just to clarify, as you said, this is an amendment to an existing law. And I'll talk a little bit later about this law and how it came to be. But that's it exactly. This is one of those amendments to this law that now we've opened it up. And you're likely, I'm guessing, going to read the exact language. But, it's the intent behind this part of the provision is so we can hold negligent institutions and institutions that have caused institutional betrayal and trauma because of their, gross negligence or their, willfully turning a blind eye to these horrible things that are happening. So now we do have, survivors have a remedy under this statute.
Right, and that's great. Another thing about when this is going into effect, so we have March 1st, 2023 as the effective date. And this look back period, from my understanding, is that it's going to close on March 1st, 2024. And that's going to be the year of opportunity for survivors who want to seek justice under that. So one of the
yeah, if I could just jump in. Oh, excuse me, I went right out of the frame. If I could just clarify for one thing, though, that start is just about the window, similar to how the CVA had provisions that immediately changed. Those other provisions in this code, I refer to it as a statute, but it is a code, as you said. Those are now the laws passed. So if and we can talk a little more about this, but if you have, if you've been the victim of sexual violence and you're seeking the civil remedy through this code, you can currently sue an institution as part of your lawsuit. Oh, wow. Now you don't have to, so that window is for if it's time, if your time is expired, right? So that's a wonderful thing, is that those amendments to this important code about being able to sue a negligent institution, being able to sue the university, right, that's now, but we have this window that's also going to open, as you said, for those that ran out of time, right? The same as the Child Victim Act. They for the reasons we know why, they were not able to bring a claim. They weren't able to report the sexual violence against them, and their time passed for them to be able to bring the lawsuits. Now, just like the CBA, in the sense we have that window, but just to clarify, those amendments, that as of January, those amendments are in effect.
So you're saying, Kat, that if someone right now wanted to use the Gender Motivated Violence Act to go after an institution and file a claim against an institution that failed them, and they were maybe this person was sexually abused while under the care or custody of that institution, they could do that right now if they wanted to. They don't need to wait until March.
I will give you an example, and it's public now. It's on the public docket. I will give you an example of our client that was able to sue. She was still within. So the original code, the Gender Motivated Violence Act, gave us 7 years. Gave a survivor 7 years. That was really important. So this client was still within those 7 years from when she was sexually assaulted by a doctor. So as soon as the Gender Motivated Violence Act was passed, we filed the lawsuit because we were still within those 7 years, and we filed against the negligent medical institution that allowed for this doctor that they knew about, that had criminal history, we filed the lawsuit against against the institution using the Gender Motivated Violence Act. And we didn't have other remedies, and this one was available to her. So yes. So to answer your question in a very long-winded way, yes.
No, that was not long-winded at all. It's great to know that people don't have to wait until March 1st, 2023, because right now we're seeing a lot of conflicting information. It's really tough when something new gets passed, and it can be confusing for survivors out there who want answers, and even for some of us attorneys who are trying to figure out where do we stand with this right now, right?
Yeah, so it's not, so it is, so again, it is someone who is still within those 7 years, if the assault happened within the last 7 years. So they still have to be within that time frame. And then if someone, if it's been beyond those 7 years, then we need the window.
Right. Okay, great. So then this, for people who otherwise would have been, time barred, and if you are time barred right now and, you're consulting with an attorney on this, that window will open up for those victims, for those survivors who are time barred, March 1st, 2023 to March 1st, 2024. That's going to be your window. And if you're not, then start consulting with people like Kat Thomas, because these windows are open for, for certain people that fit the criteria, and speak to an attorney to find out if that applies to you.
Yes. Speak to it. Find an attorney just to see what your options are, because it is a confusing landscape. So yes.
And one thing that's really different about this specific law than we've seen in the Child Victims Act, for example, which the Child Victims Act that was passed in New York State covered the whole state of New York, right? Now, this is a New York City specific law. So, unfortunately and fortunately, in some ways, this is only going to protect and it seeks to find justice for people who were abused in Manhattan, Bronx, Queens, Brooklyn, Staten Island, within the 5 boroughs of New York City. The question is not, where you live right now or where this abuser institution is located at the moment. It's really about, and Kat, please correct me if I'm wrong here, about where did that abuse take place, right?
Yeah, I mean, it is a bit, it's getting into a confusing area of law where the word we use, right, is jurisdiction. What's the jurisdiction? Does the court have power over your case? For a court to have what we call jurisdictions, like does the court have power over the case? So, this may become an issue. But yes, you're correct. For purposes of this code, it is just for the 5 boroughs. If the sexual assault happened within the 5 boroughs, again, there's nuances, there's exceptions. This could be an issue that starts to come up in the courts, but at a very basic level. And this is why we always say, please seek the advice of an attorney to figure out and suss out all these, very nuanced and messy areas of law. But yes, the intent is it's an administrative code just for New York City. And this is also why, we continue to advocate for the Adult Survivors Act that gives New York as a whole, survivors all over the state of New York, the opportunity to bring their lawsuits and seek restorative justice throughout New York. Because right now, as you said, an unfortunate, but it's good that we're taking steps, and the city is taking steps. But the unfortunate part is, people in Albany that were abused in Albany, that they're perpetrators in Albany, everything's in Albany, are not going to be able to bring to file a lawsuit under this code. Excuse me. Yeah.
Right. I know it's difficult because it's called the Gender Motivated Violence Act, but we're referring to it as, under the code, under the law. So
right.
Our apologies in advance, because everyone's still trying to get a grasp on this, right?
Yes.
And then for some of the relief that survivors can get out of this, the potential relief we have, I'm going to read the list here that they've provided, is compensatory and punitive damages, which is a form of monetary damages, injunctive and declaratory relief, attorneys' fees and costs, and, of course, the caveat, any other such relief that a court may deem appropriate. So this is really, of course, it's different than seeking justice in a criminal court. This is a form of civil justice where monetary compensation is on the line. So that's where we're at right now. And I wanted to give you the opportunity, Kat, to talk about some of the really important case law and some of the intricacies and the nuances of the Gender Motivated Violence Act, because I know that you really have a firm grasp on this. So I'd love for you to chat with us a little bit about that.
Oh, you are giving me way too much credit. I just think that this is a very important code, and I'm so glad we're doing this. And Helene, thank you for a wonderful explanation of the law and breaking it down so that we can all understand it. So I really appreciate that. And I really appreciate that your law firm is hosting this, because it is complicated, as unfortunately so many codes and laws and rules and regulations trying to provide justice for survivors are. I mean, it is very confusing. As you said, even for attorneys. So I did want to give just a little bit of a backdrop and talk about two cases that have successfully applied the Gender Motivated Violence Act, and survivors were able to get restorative justice from using this important code. So way back in 1994, after 4 years of hearings, the Violence Against Women Act passed. And this was a really, really important, at least on paper, because it was finally saying this sexual violence that women are experiencing. At the time, it was very focused on women, says gender women. Since then, we've expanded that, and we understand it's way more inclusive. And I'll talk about that. It's way more based on gender violence. But this was really important, because we finally said this isn't a private matter. This isn't, it's not just we don't want to deal with this if there's a domestic violence issue. If your husband's raping, that's not a federal, we're sorry this is happening, but this isn't a public thing. Right. Finally, after serious advocacy, these advocates and attorneys and legal momentum and just, people like Julie Goldshy, who is an amazing advocate and is a large part of why we have this code, would no, this is a public issue. When you harm people at this level, everyone is harmed. The people that suffer from sexual abuse as children, we know they don't do as well. They can't contribute to society and contribute to the economy the way others can. And that's a huge issue. And I know Marcy talks about that a lot. And so it was finally recognized. This is a political issue. And so it did these amazing things. It funded a bunch of money to law enforcement to help fight domestic violence. It was this amazing immigration status. Domestic violence survivors finally had this other avenue of getting legal immigration status if they were domestic violence survivors and they didn't need their husband for it. So it was huge. And then they said, okay, and you now can sue under this federal law, you can sue your perpetrator. And then everybody lost their collective smurf and it was that, no. We're federal law. We don't allow remedies like this. So there was a case that struck down the survivor's right to bring a lawsuit against the person harming them. And it was a horrible thing, because there were, this is going to be says gender bias, but this was the origin of it. There were mothers that were getting badly beaten by their husbands. It was sexual violence, gender-based violence. And one of their only avenues was to sue the perpetrating husband so they could finally collect for their child, to get into treatment and get better. And this was struck down. So New York City responded quickly and said, we're going to come up with a law that, and it was housed in the human rights part of the city code. And it was specifically to help end sexual violence. And it was couched as a public safety issue. It was to keep we said that we needed to keep our citizens safe. And so it went from the human rights, and now it's in this part of the administrative code it's in now is a public safety provision. So this was, we find we need to keep our citizens safe from sexual violence. So the two cases, the first one, both these are like, so in New York, there's like the Supreme Court and then an appellate division and then a court of appeals. So this one's at this important level of appeals. Both of them are, they reached a second level. And it's very important when a case goes up to the second level of appeals. And at this, and this case is called Breest v. Haggis. And the question on appeal was, what does a plaintiff need to allege for a claim to come under this important code, right? This Gender Motivated Violence Act we're talking about. What will a plaintiff need to actually prove? And Helene already went through kind of the elements that are in the statute. You know, it must be a crime of violence, motivated by gender. And I don't want to repeat everything she's already said, but yeah, you know, and as Helene said, what a crime of violence is. But the language specific that crime of violence committed because of gender, on the basis of gender, and due at least in part to an animus based on the victim's gender. This is where things got tricky. Like, what does that even mean? What does the word, what does the word animus mean? What's that?
That's what I wanted to talk to you about, is because I think, you know, some of the feedback, at least that we've gotten recently, based on the way it was worded and based on some of the legislative history that was involved, people were wondering, you know, well, is this only going to protect women? And so I thought that was something, you know, that you could also talk about as you're talking about these really important cases.
Yeah, and exactly. Yeah, no, thank you for bringing that up. One, we know from the legislative intent and the legislative history behind the Gender Motivated Violence Act, is that it specifically did want to cover the LGBTQ community. But more importantly, according to the court, that this is not, you don't have to, so, you know, the arguments around this, like a defendant's argument is like, you're going to have to prove that this defendant hated women. You're going to have to prove it. You're going to have to show he was cursing out women, not just this woman, and hated her. Like, I'm going to do these awful things to you because you're a woman. Oh. Beyond that, you have to prove, I hated all women. Women are the devil, whatever. And that's an insane standard. And luckily the court agreed that that's an insane standard, that you don't have to, because of the nature of what we're talking about, victims don't have to prove that. And the court is clear. The court is clear that it's the nature of the crime. The most important, I feel like, language of this case that I'm talking about, this Breest v. Haggis case, is the court says that animus, and here's where consent is absent. Okay, so what does that even mean? So one, animus, like, what does animus mean? Does it mean you just don't like something? Does it mean you have willful malicious intent? Like, what does having an animus even mean? And they can't even agree on that. There was like, you know, 10 amicus briefs where we can't even agree on what that means. Yeah. But the court was like, if there is a lack of consent plus the sexual activity, you've met your statute. You've met it. You've met your the element that you've had to prove. If we're talking about a sexual act, so this is where we can compare to the Child Victim Act, right? Because under the Child Victim Act, it says Article 130, and then, oh, James is going to kill me, but the other two criminal codes that have to do with child pornography and incest. But
260 is one of them, I believe, and then we've got Penal Law 130 is the main one that the main one. Right. So
yeah, thank you. Yeah. So if it's a sexual act, a criminal sexual act, plus which there's no consent. So that's it. There's a sexual activity. And this statute's great because it doesn't even limit you to the code. It's like, if there's a sexual activity, a sexual act, plus no consent, you've met it. and as you and I discussed before, when we were talking about doing this important talk, there is going to be some back and forth in the courts. We believe there is going to be some, like, what about where there's not a clear, first degree rape? What are they going to do if it's in the workplace, but there's not a sexual act? Are you going to have to kind of prove that perpetrator did have an animus? And I think that's why it's also important with the other case, Engelman v. Roth, does discuss this. I'll get to that in a second, but I just want to make sure that it's clear that but with this important case, going back to excuse me for 1 second, just the Brees v. Haggis case.
Yeah.
That they answered this question about what does a plaintiff need to allege for a claim under the Gender Motivated Violence Act. I mean, I think it's just so wonderful that we already have this case in place that is clear that it's just about a sexual activity and that there was no consent. We don't have to, they're not going to have to prove what we were talking about. You're not going to have to say, well, he told me this. Here's the text messages that said, I wish all women were dead, or anything like that. Like, the court was like, no, that's not appropriate for a survivor to have to do.
And then another thing, just as you're talking about that, like I mentioned before, not only do we not need to prove that, we are not going to have to prove that this person at any point in time was convicted of this crime at all, or even was arrested for this crime.
Yeah, no, I'm so glad you brought that up, because that's an important part of this, of this code, is that we don't it's a recognition that, unfortunately, in so many ways, the criminal justice system has let survivors down, and there's underreporting, and there's a bias against victims. We know this by numerous studies that the city's conducted about law enforcement, that the victim is generally, unfortunately, still not believed. So I'm really glad that you pointed to that. That's a very important part. And so to, again, remind our audience that we're not talking about a criminal code here. This is for civil remedy and civil court, where you can get damages and be compensated for the harms that you've suffered. And I believe it's a shift in fee shift, right? It's attorney's fees. Is that right?
It does provide, as one of the potential remedies, as we have compensatory and punitive damages, and then attorney's fees are also listed as one of the one of the remedies that are provided under this law. So, there's opportunities for plaintiffs to be able to, get that justice in a monetary form.
Yeah. Awesome. And then really quickly, and if people follow up with you about these cases, I'm happy to provide our audience with a citation to the cases.
Awesome. I was going to ask for that.
Yeah.
We'll make sure that James has some links for us for this. This great talk we're having.
Yeah. Awesome. So then the other case that's really important, and came out in 2021, December 2021, is Engelman v. Roth. And this case was because is a little bit of a different argument. It's not about what does the victim have to prove. This one is about, well, this whole Gender Motivated Violence Act, you can't do that. You can't do that. That you're overreaching, city of New York. You don't have any right to do that. So that's what this case is about. And just a very oversimplified crash course in preemption. Yeah. So preemption is, if the federal law, like the tippy top, right? The U.S. Supreme Court, Ginsburg, all that, if they make a rule, or if the federal, and they've occupied a certain area of law, the state and the city can't touch that, right? So they don't get to mess with that. That's the high court, right? And then we have state laws, which is where the Child Victim Act is, where we really hope and believe that Adult Survivors Act will be. Yeah. And those are state laws, right? Mm-hmm. And So those state laws, the city of New York, the city code can't mess with those. They can't preempt those laws. So this case, Engelman v. Roth, was in part about saying, city of New York, you can't pass a gender motivated act. You're getting too big for your britches. There's already, and they focused on this 7-year window. They're like, there's already this thing called the CPLR. What does the CPLR stand for? We say CPLR so quick and shorthand. Civil procedure laws and rules. Basically, the thing that tells you how much time you have to bring a lawsuit. They're saying you can't. You're overstepping your bounds. The state's the one that gets to decide how long you have to bring your lawsuit.
Right.
And they've spoken in this area. They've already said assault, you get 1 year and that's it. That's it. They've spoken on this issue.
Yeah.
Luckily for us, the appellate division, remember I said the important appeal court said, no, that's not what this law is about. This law is not about assault. It's not about battery. This is a human rights law to protect. It's a public safety law.
Right.
It's in human rights. It's a civil rights law. This is not about an intentional tort.
Right.
We're trying to protect survivors. We're trying to protect against domestic violence, against
brings it all the way
violence.
back to what you were just saying at the beginning, that the whole purpose, the whole reason that this was passed and what they're seeking to do is it's a public safety issue.
Yeah.
Sexual violence, and how amazing is it that this is now being recognized as a real, tangible issue that our lawmakers are taking seriously.
Exactly. And so, yeah, so we have these two very important cases that are one, says, just to recap, these two important cases, one that's telling us, look, if it is a sexual act and there's no consent, that has proven that part of it. I mean, you have other things your attorney's going to have to prove, or you as an attorney are going to have to prove, obviously. But when we're dealing with this fuzzy animus word or due in part because of gender, it's not about if it's a man. It's not about if it's a woman. It's about what the actual sexual act. And then on top of that, if there was no consent. And then this case I was just telling you about, this Engelman v. Roth, reiterated that same exact language. That's in there once again. This whole, I want to get the direct, this animus inheres where consent is absent. Right. So that was repeated in this other case. They borrowed that same language. And then this case says, because of the source of the Gender Motivated Violence Act, and because this is, just as you said, a public safety, this isn't about the CPLR, or this isn't about an assault or a battery. This is about protecting against this kind of violence that is, it's a epidemic in our society. We recognize this now. This is a serious, serious problem, right? And Helene, and I, we both as litigators for survivors know that it's a severe, severe problem. We're just finally addressing.
Right.
So yeah, I'm really glad I was able to talk about these two important cases today.
Yeah. No, thank you so much, Kat. I mean, I think one of the most important things when we're talking about these look back windows and these new windows of opportunity really that are opening up for survivors, it's so important for us to recognize that one of the biggest reasons that these look back windows have been passed recently is that as a society and our lawmakers too are recognizing this fact to be true, that it takes a long time for people to come forward, for survivors of sexual violence, for survivors of a lot of different forms of violence, but for survivors of this type of abuse to come forward and to say, this happened to me and I want to do something about it. I want to seek justice. That can take years and sometimes it can take decades. And so it is just really important that we have, lawmakers that are taking this into consideration, that are looking into the statistics of people who, statistics show takes sometimes decades to come forward and tell the people they love the most what happened to them, and now to be given this opportunity, this look back window that's again opening up in March of 2023. And it's just, it's phenomenal, and we hope that this can provide survivors with some form of restorative justice for them. And I really can't thank you enough, Kat, for joining me and discussing something that is just so important.
No, thank you so much for having me. I'm glad we're finally, getting this moving. As you said, it's an introduction. We're gonna keep the conversation going.
Yeah, this is just the start. I'm sure we're going to be talking about this a lot more. I'm sure as developments come out, we might even want to jump back on and have another talk. So we really hope that this was helpful for a lot of people out there, and we'll make sure to provide some resources and some contact information for Kat and for myself and for the Marsh Law Firm. So thank you again.
Thank you.